Stay positive and persistent at Game Devs. Tony Chan here, and welcome to episode 79 of Game Dev Loadout, where I chat with the best people in our industry every Wednesday morning. If you need motivation and tactics for a successful gaming career, then this is the podcast for you. Now let's chat with today's featured guest, Gary Nissenbaum. Gary, it is a game time. Are you ready?
I am absolutely ready, Tony, and I'm thrilled to be here with you. And I'm looking forward to this topic. It's really something that I think is going to be very interesting.
Oh, I already love the attitude, Gary. He is the managing attorney of the Nissenbaum Law Group, a law firm that represents a wide range of business clients from single-person startups to multinational corporations. One of the firm's focus involve intellectual property matters, including entertainment laws, apps, websites, and video game. I should add that nothing that is discussed today should be considered legal advice or opinion on any specific matter. If any of our listeners have a legal matter, they should consult counsel of their choosing. So, Gary, please tell us generally about your law firm.
Well, we are actually a modern version of a commercial law firm in the sense that the focus of our law firm is, generally speaking, representing people with business issues and representing businesses. However, the digital world has sort of welcomed us in a very, very interesting way. And a lot of the commercial work that we're doing now resides in the area of entertainment law, which is film, motion pictures, television, modeling, literary, music, and then the big one, number 6, which is video games and apps. And the reason that I'm on your show and I wanted to speak to your listeners is that we have really been doing an enormous amount of work with video games and with apps that are video games, and then the licensing of these with respect to films and television and other things like that. And so we're sort of in this world from the perspective of the law. And I think that if you take the legal principles and you then take the principles of what makes a good app or video game and you sort of put them together, I find that to be fascinating.
Yeah, and with the video game industry booming, there's like a ton of things we just got to be careful about in terms of IP. So please tell us about your law firm's practice regarding the licensing of IP involving apps, websites, and video games.
Well, the most interesting thing to me is the overlap. I mean, it's apps, websites, and video games in many ways are so interrelated that there's almost no difference in terms of the types of law that you're dealing with. Basically, what we're talking about is intellectual property involving copyrights, trademarks, issues involving registration of those, issues involving infringement of them. But then beyond that, we're dealing with non-compete clauses, employment agreements, independent contractor agreements, starting a business that gets involved in this and how to do that and how that business can work not only across state lines in the United States, but also internationally, and how you can protect intellectual property outside the United States and inside the United States and how that's all linked. And then you take that entire thing and you add to it what we call annuitization, which is really just a fancy way of saying that we're creating an annuity of the intellectual property so that something that starts as an app or a video game, and that's what's being sold, then becomes a toy, apparel, an image on a bag or a bookcase, a backpack, and other sorts of things like that, and then segues from there into potential television, film, and other sorts of media. So what's so interesting about this is that you start with the kernel of this small little icon on a cell phone, and it can sort of blossom into this melange of legal issues and legal requirements that can create an entire panoply of ways of monetizing, of making money from for a client from just this little app that we start with.
you mentioned before that you had video game developer clients before. What were the most common mistakes that you noticed from them?
Well, the obvious one, and this is the one that I think people should listen to very carefully, is if you fail to nail down the intellectual property rights through the appropriate documentation. I can't count how many people come into my law firm and I say to them, do you have a copyright? And they say, I have a poor man's copyright, which, and a poor man's copyright, I already know what this term means now. It's not a legal term, but I know what it means because so many people have said it to me, which is basically you take whatever it is that you're copywriting and you mail it to yourself. That somehow that creates a copyright. And I keep telling them, no, that does not create the copyright. And, so nailing down the copyright, the trademark, applying to the appropriate governmental authority, dealing with it, whatever objections come our way, whatever categorization needs to be made, whatever descriptions are necessary so that you're properly describing how these things are going to be used for trademark purposes. That's critical. And that's the thing that I think really needs to be nailed down. And if it's not nailed down in the beginning, it can create all sorts of landmines later on when you have unbelievable success, but you're building your entire empire on a base of sand.
Yeah, and that's why it's so important from the beginning, if you can, to get these things done. And real quick, can you tell us the difference between trademarks and copyright materials?
Well, I think you're right that we should explain that because I keep referencing that and I want to make sure that everybody here is on the same wavelength. So I'm going to give a general definition, and then I think as we go on, maybe we can get into more detail. The first principle that you need to keep in mind is that ideas cannot be registered. That's critical. So the idea to have a love story, the idea to have a martial arts story, the idea to have a science fiction story, those things are not protectable by registration. You could theoretically have two people enter into a non-disclosure agreement. That's true. But that's a contract between two people. I'm talking about registering it with the government so that as to the world it's protected. What you can protect is you can protect the expression of the idea, the way it is expressed. And the way something is expressed, if it is unique enough, it can be copyrighted. And that's what a copyright is. So you could have a copyright of music, of a book, of words. You could have a copyright of a video. Sometimes, and this is not so simple to do, but sometimes you can actually have a copyright of the way clothing is made, and some more esoteric things that are unusual like that. But the point is that's a copyright. A trademark means that you are identifying your goods, your services in the marketplace. So the way that you are known in the marketplace, Coca-Cola, Lexus, Infinity, these are trademarks that identify the product. When I say those words, you know the product that I'm talking about. And that is the difference between trademark and copyright.
Those two things usually go hand in hand, or sometimes you just need a trademark and sometimes you just need a copyright, or do you have to get both?
Well, what's so interesting about it is they don't have to go hand in hand. I mean, if I write a book, I might just write the book and not necessarily need a trademark at all. But I'll copyright the book because I don't want someone to steal it. So there are situations where they're not tied together. But what's so interesting is sort of the reverse of that, which is sometimes when you are copywriting material, as you're going through the material to see if it's legally susceptible to being copyrighted, what you find is that the person who created this used someone else's trademark. In other words, they infringed potentially on a trademark of someone else in the course of creating material that you're trying to copyright. And that's the more interesting thing for us as lawyers. We're looking at the ways in which there is a confluence there's a convergence between what's being copyrighted and what's being trademarked. If your trademark is a paragraph of narrative that is copyrighted by somebody else, how exactly are you trademarking that when you're infringing on their copyright, and vice versa when a book is using somebody's trademark? And so that's what we're going to talk a little bit about tonight, is where is the line when it comes to doing that?
Yeah, bear with us, Game Dust. Gary's going to be going through a lot of stuff, so bear with us, and let's get through this.
Yeah, get your seatbelts on. We're taking a ride through the legal world.
So what are some of the pitfalls our listeners should be on the lookout for in either developing video games that uses characters or other elements that are already copyrighted or trademarked by someone else?
Well, a lot of it has to do with the movement that video games have been taking toward the area of being so hyper realistic. Obviously, the technology is driving a lot of that in terms of the pixels are different than they used to be 10 years ago, and the quality of the picture is different. The sound is different. There's been such a leap in terms of how realistic this stuff is, and how authentic it is. And as a result, there seems to be a movement among developers to find ways to make things even more authentic. And sometimes that means adding in actual real life references and items, some of which may be trademarked or copyrighted. And so, as an example, let's say a character shoots up an army, and then at the end decides to take a drink from a Budweiser beer. And, if you just had a picture of a beer with no logo on it, with no trademarked logo on it, it would not be as compelling as the person can actually read Budweiser and all of the different wording and so forth. Does that mean that the developer has infringed on Budweiser's trademark? And so that becomes the issue, because so many of these trademarks are being incorporated into the game, not so much to sell the product, not so much as a commercial, so to speak, but more to give a realistic depiction of the world.
So I'm assuming it's just best not to do that in general, correct? Because something might come up from Budweiser where they tell you to take it down, and then you have to edit the game and change all this stuff. So would it be better just to avoid that to begin with?
Well, it's interesting. If I passed a law that everyone in the United States on the highway would have to drive 25 miles an hour, and that was the new speed limit, I guarantee you there would be hundreds and hundreds, maybe thousands of people who would live that year who would otherwise die in car crashes or be horribly injured. Does that mean that we should change all the laws, speed limits on our highways to 25 miles an hour? And that's the conundrum that lawyers and their clients deal with. If I make a blanket pronouncement to my clients, do not use anything that could theoretically be alleged to infringe on a trademark of someone else or copyrighted material of somebody else. Well, what I'm doing is I'm throwing a blanket over their creativity, and I may be undermining their viability to create a game that's going to be a smash in the marketplace because it's so hyper realistic. So the point that I'm making, and I've been doing these things for a long time. I've been a lawyer for over 3 decades. I can tell you that one of the aims I have as an attorney and in our law firm, one of the principles we live by is it doesn't take a smart person to say no. Anybody can say no. It's easy for me to just say, oh, don't do that. It's safe. Somebody can never come back to me and say, gee, you were being too careful. I mean, what are they going to say? That I should have taken a risk? I mean, the no's are easy. Where the rubber meets the road in terms of being a lawyer is for we as attorneys to find a way of saying yes. and find a way of saying yes that mitigates the potential for the client to be sued, although doesn't eliminate it, and gives the client an understanding of what the risk is and lets the client make the decision.
Well, I really like that. So you want to keep that creativity from the developers as much as possible.
Right.
Awesome. So say, for example, that Budweiser, since we're using this as an example, what if they send us a legal notice? What's the first thing that we should do? Should we even reply back to the person, or should we just wait?
Well, let me restate the obvious, which is if you get a notice like that, the first thing you should do is investigate whether it's spam, because that sounds like spam. And I mean, I'm in the legal world. I'm not even in the digital world the way your listeners are. And I get so many people trying to scam me into thinking that there's some existing lawsuit when there isn't, or some kind of legal matter when there isn't. There's some kind of bot that keeps sending me the same email every morning. Literally every morning I wake up and it says, I'm doing a purchase agreement in your area and I need an attorney to handle it. Are you available? But it's the same stupid email every single day. I know bots. It's not real, So that's the first thing. The second thing is, if it is real, you must get a lawyer involved at the inception. And the reason is this. It's highly likely that if somebody had gotten to the point of sending you a cease and desist letter or email, they are at least consulting with a lawyer, and it may actually be coming from a lawyer. So you are punching above your weight. You do not have the ability to know the different principles and concepts that person knows. So it's an unfair fight. You really got to get a intellectual property lawyer involved to evaluate what the cease and desist is saying, and possibly even tell you that you should ignore it, or that you should deal with it, or here's how we should reply to it. The likelihood is that a lawyer will not have you reply to it. The lawyer will probably want to reply to it him or herself. But the point is, you really need to get a lawyer involved at that point.
What if, since we're indie developers, we don't have a huge budget? What if we can't get a lawyer? What else can we do?
Well, let me put it this way. A lot of this is risk reward. If you want to be in the digital world and you want to be successful, there is a way of doing it in which you are jumping with no net. And you're just assuming that everything will work out. And there are people who do that. And they get away with it because there's just a statistical probability that not everyone is going to get nailed. So I understand that. But it's not the way that I like to conduct business. It's not the way that my clients generally conduct business. And it's also unfortunate because the need for an attorney is really at the beginning, because that's when this thing is unformed. That's when you're making decisions that you're going to have to live with for years on, the years thereafter. So the point I'm making is that as much as it's going to be a stretch for your listeners to be able to hire a decent lawyer, you really need to factor that in and make that a priority. Perhaps you get a consultation with that lawyer, and at least you get some input, and then you see if you can ask the lawyer for alternatives. When we deal with new clients, what we try to do is give them a range of options, and then give them a sense of at least the starting point in terms of legal fees or retainer. I don't like to just drop one alternative on somebody. I like them to feel like they're making the decision. So we give them a range, and sometimes they're less expensive, sometimes there are more. It's just that you are obviously taking more of a risk, usually with the less expensive approach.
Yeah, and I generally always tell people to go to an expert for these type of matters, because it's just a lot to it, and an expert would definitely help on that part. Do you have any examples of the legal principles at play here?
Well, there are really two that come to mind right off the bat. The first is something called the idea expression principle. And that is a concept that I want your listeners to keep in mind when they are creating their games. You are copywriting the expression rather than the idea itself. The idea itself, generally speaking, is not copyrightable. So just make that distinction. If you have a video game, think of the idea of that video game as something that is open. Let's call it open source, just to use a term. But the expression, that unique way of expressing it, is something that hopefully, if it's done well, you can protect. And the second concept that your listeners should keep in mind is something called the first sale doctrine. And what that means is that when someone purchases your video game, there is a legal principle that allows them to resell it because they already own it, because they bought it. And so the first sale is the one that's protected. That's the one where they have to pay you. You're the developer, the owner of the game. But after that, they can resell. Now, that is limited in a very, very direct way when it comes to video games. And that is that if what they're doing if someone is reselling it, by literally copying it, packaging it, and selling it to other people, the first sale doctrine should not be able to allow them to do that. They should not be able to literally strip away the entire game and just start selling it to 100,000 people and making money on something that you've copyrighted. So there is this tension between these two ways of looking at the world. You know, for the idea of first sale really is tied in with another concept that is important and another legal principle that we should know about, which is fair use. Am I allowed to strip your entire game that you've sold to me and then call it the Gary Nissenbaum game, and now off it goes and it's being sold? No, I'm not supposed to do that. That game has been copyrighted by you. Mm-hmm. But am I allowed to use a portion of what you've copyrighted so that I can write a blog critique of your game? There you have this concept called fair use, which means doing a critique of your game. Here's what I like about it. Here's what I don't like about it. Here are some elements. And here's a snapshot of that game. Or here's a few lines of dialogue from that game. And the law generally will let you do that within reason. And the question of where that line resides is why you need a lawyer.
Wow. I'm trying to process all this into my head right now. Expression idea, which could be copyrighted like music, first sales. So if someone buys a game, they can actually, or depending on where the line is, they can resell it. Yeah.
But they're not allowed to literally just take the entire game, copy the whole thing, repackage it, and then just start selling it all over the place.
Gotcha. So how do the court approach the issue?
Well, there's a bunch of cases that have come down that are pretty significant in this area. And most of them, stem from this sort of a root, and then there are branches that came off of this. The case of Brown versus Entertainment Merchants, which is a Supreme Court of the United States case from 2011. And basically, this was a case involving a statute in California that would stop people from selling violent video games. And the counter to that was, hey, I have a First Amendment right to sell a violent video game. So you're not allowed to stop me. And up until then, with some exceptions, the general thought was that there were no robust First Amendment protections for video games. In that case, that was a pivotal case. The Supreme Court said that there was basic First Amendment protection for video games. So that's where this sort of begins in terms of my analysis. And then there's a bunch of cases in which you keep seeing this tension between the concept of whether a game is infringing and whether it's not. So I want to give you two examples of that and to sort of show you the difference between the two. There's a case involving Tetris. This is a 2012 case out of New Jersey in the federal courts. And Tetris Holdings had a lawsuit against Zeo Interactive for a game called Mino. And the idea was that Mino was alleged to be infringing upon Tetris. And the idea was, well, what is it that Mino copied from Tetris? And if you look at Mino, from what I understand, it's more than just the rules of the game. It's more than just the principles of how these geometric shapes all will fit into one another to then allow you to go to the next screen and that sort of thing. That it was far more than that, and that Mino was copying the design of Tetris, that it was copying the the feeling of playing Tetris, so that when you played Mino, you felt like you were playing Tetris. The court mentioned the style of the pieces is nearly indistinguishable, both in their look and in the manner they move, rotate, fall, behave. Similar, I'm quoting from the case, similar bright colors are used in each program. The pieces are composed of individually delineated bricks. Each brick is given an interior border to suggest texture, and shading and gradation of color are used in substantially similar ways to suggest light is being cast onto the pieces. So the idea was that this is more than just, hey, the rules of the game involving geometric shapes are the same. That's not what's going on here. What's going on here is when you play one, you feel like you're playing the other. So that was ruled to be an infringement. You were not allowed to do that. So let's contrast that with another case, which is Da Vinci versus Zico Games. It's a Texas case from 2014, federal court. And in that case, the two games were Bang and Legend of the Three Kingdoms. So the issue here is that Bang, which is a card game, it relates to West, the Old West. It's sort of a Western. And so the comparison there was whether you had a game that was involving Chinese martial arts instead of the Old West. And so if the difference between these two games is that one is involving a fight, a shootout between Chinese martial artists in ancient China, Kung Fu experts, as opposed to the Wild Wild West where everybody's shooting them up, but it's essentially the same thing. Does that mean that one game is infringing on the other? And what the court said was that it wasn't infringement. And the reason was very interesting. The reason was that the similarity between the two games was really about the rules of the game, the way the rules were structured. Admittedly, the rules were the same. The procedures of how the gamer will win or lose the game were the same. The conditions for winning were the same. But the actual feel, the environment of the game, the feeling of playing that game, the actual way it is expressed was radically different. It was two different historical epochs in two different parts of the world. the events, I'm quoting from the case again, the events in a Bang game are not predetermined because the interactions between the roles have no script or detail and are not fixed, making certain roles aligned with and others opposed with is part of the others is part of the game. It's part of the conditions of the game. And these determine little about how players progress through the game. So the idea is that the way the characters interacted was not predetermined. It was something that the player would actually come up with. It was more that the rules of how people would win the game, I assume it was about who could kill who or who could defeat who, even if they're not killing the other character. And that is not protectable. So the basic thrust and what I'm trying to get across is that, what you really need to be doing as a developer of games is you must be coming up with something that is far more three-dimensional. You have to have an approach that is far more unique. You can use the principles of other video games, just the instructions of how they play. That's probably okay in the abstract. Although each situation is different, and I can't know in advance without seeing it. But generally speaking, that's on the right track. It's more along the lines of, have you created a three-dimensional world in which the interaction of these characters is so unique that it really is not copying that of the other games? And have you created designs and elements that are so different than what's come before? And that's really the challenge for the gaming developer. I realize that it's easy for me to say, hey, do something unique. It's not as easy to do it. I get it. But that's where the rubber meets the road when it comes to the legal issues here.
Yeah, that's just incredible. And so, game devs, you got to get your game out there, because the market is just, a lot of people are putting games out there. And so the less you wait in making your game, the more you got to confront with these different policies and laws. So get to a game devs, start making these games. And can you give us some practical examples of how all of this applies to video games?
Well, I'm going to give you another term. And again, the reason I'm giving you these terms is they're terms that your listeners can Google these terms. You can read about these terms, and it's good for you to know the terminology. There's something called the Scène affaire. Scène affaire is it's spelled scenes, SCENES, then the letter A, then fair, FAIRE. It's called Scène affaire. And the idea is that you're trying to create a feeling of being in a world, that the scene itself transforms the player into this world and lets the player enter a world that is self-contained, with its own principles, with its own characters, and there's an internal logic to it. And that is what you want to start with, because there should not be a copyright protection for a scène affaire. A scène affaire could be as something as simple as, I'm in the wild, wild west, I'm the sheriff, and there's a bunch of bad guys, and I'm trying to rescue the damsel in distress. That's a scène affaire. I'm in space, and there's a rocket ship. We're running out of oxygen, and we have to figure out how to repair the spaceship. That's a scène affaire. Those things ought not to be protectable. The key there is that what you want to have is a sense that the scoring and point systems, the rules and mechanics of how this is done, the general workings of the game, the way the game is constructed, is something that can be the same from game to game without normally infringing, without normally leading to a lawsuit. That's the concept you want to have. An example would be if I have a house, generally speaking, the way that I do the framing, the type of wood you use, the type of, how large each of the steps are and how far the steps are from the door and how large the door is, these things are standardized. They're not unique. They're not really artistic expressions. But the way I paint the house, the colors I use, the shingles that I use, the little decorative bird that I put on the outside of the door, those things are the artistic expressions for that home. And so if you make that distinction between those two, that really will help you understand what you can do here.
Yeah, and the more I think about it, if you think in terms of avoiding copyright or trademark, it actually kind of forces you to be more creative in your game process.
Exactly.
Yeah, I never thought about that. That's a really cool way of thinking about that.
So in other words, the lawyers are helping you create.
Yeah.
Which nobody would assume.
Yeah,
right?
You're helping us be creative.
We're spurring you on.
If one of our listeners is confronting these sort of issues, what should they do? Because, of course, we should hire a lawyer. What is something else in general that we should do?
Well, there are a lot of materials on the web that can at least give you some idea of what you should be asking a lawyer. I'm a big believer that you do a little bit of your own research first, so that not so much to get the answers, but again, to get the right questions. My website, gdnlaw.com, gdnlaw.com, has a lot of resources on our internet law page. We also talk about apps and video games and other things like that. So feel free to take a look at that. But there are other resources as well that you can go to that will help you with that. And I think that if you start that way and then get in touch with intellectual property counsel, somebody who actually knows this area. And I guess that's the second thing I would suggest is, in medicine, the physicians have residencies and fellowships that give them specializations in different types of illness and different ways of treating patients. In law, we have some of that, but not as much as they do in medicine. And so, generally speaking, it's difficult to really know whether a lawyer is well versed in something or not. And so what I tell people to do is ask questions. Don't just assume that because somebody has a name that you've heard on a commercial, or they have a law firm of 1,000 lawyers, that somehow that means that they are the person for you. Ask questions, be an informed consumer, and that involves going and doing your own due diligence before you call that lawyer, so you know what to ask.
Yeah, assumptions is a dangerous kind of mindset. So asking questions is definitely something we should do. And that's another thing on the game dev subreddit. People try to give advices all the time, and I'm always conscious of it. So what are bad recommendations do you hear in your professions?
Yeah, well, actually, I do have an example of that. It's funny you should ask me that, because there's something that happened maybe 5 years ago, and it's always stayed with me. And I want to share it with you. I had a client who was starting a business, and she had us do her customer agreements, create her limited liability company, do her operating agreement, and a whole host of other things that we were doing. And when I asked her, do you want me to handle your trademark? She said no. And it was just unusual because you were handling everything else. And so I said, if you don't mind my asking, why is it you don't want me to handle your trademark? And she said that she had gone to one of these other web-based places to be able to register a trademark on her own, and they had done it for her. So they're quick to say, we're not lawyers, we're not giving you legal advice, but here's a price, and it's always a discounted price to do this. And so she went on one of those sites, and she said on that basis she had a trademark. So you know what I did? I did a search to see if she had the trademark that she thought she had, and she did not. She was not registered. And I showed her that what they had actually done was they had given her an intent to use, which means that you can reserve the right to file your application within a certain number of months, say 6 months. And then when you do that, it relates back to the original filing. That's all she had. And since she didn't realize that, and the 6 months had already expired, she had not saved money by doing this. She had wasted her money because she got a reservation and she never used it. And if you look at what they gave her, in the fine print, it sort of mentions this and that, and it's somewhere in there. And I'm not putting them down. All I'm saying is that she did not understand it for whatever reason. And the funny thing is, she then turned to me. You know what she said?
What?
She said, "Can I sue them?" So now she wants me to sue them for doing this. Which is actually funny, but it's not so funny. So we took care of that, and it kind of had a good ending because I asked the right question, so we could help her. But the point is that these discounted sites where you can sort of do your own lawyering, there is no substitute for having a competent lawyer look over your stuff. And I know there's a cost to it, and I understand that, but you get what you pay for. And these discounted sites, you're taking more of a risk generally than you realize.
Yeah, especially if your game does become huge and successful, and then the trademark or copyright goes wrong, it's just the implications or the adverse effect of that could be like really, really bad. And so, like you say, it's best to go to someone that's competent, such as yourself. Yeah.
Well, let me give you sort of another way of saying the same thing, which is you're not creating the video game to fail. You're creating the video game to have unbelievable success. So if your video game fails, nobody cares. What's the difference if you have a copyright or not, since nobody's buying it? That's not the aim. The aim is to have wild success, to be the next game that just sort of gets over the top. So if that's your aim, you have to protect your intellectual property, or else you're going to have tremendous success and then lose it all. So what profit is there if you cannot keep that profit?
Exactly. Is there an easy way to figure out if something is copyrighted or trademark?
Well, actually, it's funny you should say that, because there's two levels here. You can do an initial search of a trademark by going to the United States Patent and Trademark Office website. And by the way, let's be clear, that's uspto.gov. That's not uspto.com. Okay, it's a big difference. So it's a .gov domain, and you can do a search there. You can also go on copyright.gov and do a copyright search. However, I must tell you that is not 100%. It's terrific that the government gives us this resource, and it's a great start. But I am absolutely convinced through just experience that it's not a complete search. And so what we do with a client is the client will come to us and say they want to register a a trademark. And we'll say, well, the first thing we're going to do before we file the application is we're going to bring in a private investigator who focuses in intellectual property, like a specific private investigator who we know who does specifically this kind of work. And it's not horribly expensive. It's a flat fee, and he has special databases that he can go to that other people don't necessarily have access to, and he can run up a report and sort of show you because the answer normally there are exceptions, obviously, but the normal answer you get is it's not that it's infringing. It's not that it's not infringing. Normally, it depends. It depends. Maybe, maybe not. And here is a report explaining, what all the trademarks are, showing you the trademarks, and then you got to make a decision on what your risk tolerance is to apply for something that you might or might not get. And even if you get it, you might be challenged by some other person who thinks that they own the intellectual property. So the first step, as I said, I believe, is getting one of these private investigators that and they're not readily available in the sense of they're not like a normal private investigator who's investigating a crime. This is a special type that does intellectual property work.
I never even heard of a PI or private investigator for a copyright material trademark. That's insane. Wow.
We work with them. Yep.
Oh, wow. Wow, this is so deep. Awesome. The show isn't over yet, Game Dust. Before we go into the lightning round, if you enjoyed the episode and want to hear more awesome content and resources, make sure you subscribe to the podcast on iTunes or Overcast. So, Gary, I will ask you quick questions and you'll be giving us more valuable information in return. Are you ready to crush it and release the show?
Sure, absolutely. Love
to. Should people be afraid to join the game industry due to all these rules? And it is a lot to it, but should we be afraid to join?
No, it's part of doing business. And, we represent a lot of businesses. And I will tell you that part of doing business is being prepared, mitigating the risk. And when you take that as far as you can take it, then you got to jump in. Then you just got to go for it. And that's the way we work. And part of that is getting the right professionals involved. That's an accountant, a lawyer, an IT person, whatever you need. You get the right team together and then you go.
Yeah, that's just like a regular business. Like, you need those things in place to be safe and, to mitigate issues. Well, what's the best piece of advice you want to give us game developers?
Well, it's to not get lost in all these legal concepts. The same way you shouldn't get lost in all the tax implications of what you're doing, because there are accounting and tax issues when you're dealing with intellectual property and it's increasing in value, and you have to account for that. What you have to remember is it's an artistic endeavor. You are being the artists of our age, which means that you are part of the digital world, but you're part of the creative world as well. You're at the interplay of the two. And that's the more important thing. The other stuff here is secondary. You have to find professionals who can respect what you do and the artistic expression and the difficulty it is to create on this level, but at the same time, point things out in a way that does not inhibit that, but protects it.
It's amazing hearing you talk about game developers and like protecting our creativity and making us prepare for the outcome or things in the future. That is really cool to hear from you. So what are personal values do you seek to bring to representing gaming clients?
Part of what I like to bring to representing gaming clients is to listen to them. I find that the worst kind of interaction with a professional is when they are lecturing you and basically telling you what you should be doing in your own industry. I have a lot to tell you, and I have a lot that you need to know that I can give you by way of understanding these concepts, but I can't do it unless I listen to you first and understand what your goal is, what you're trying to accomplish, where you're going with your career and where you're going with your video game, what your audience is, do you want to stay domestic? Do you want to go international? Why? Once I understand all those things, then I can help you. But if I just walk into the room with the arrogance that sometimes professionals have, and not listen to you first, then I am going to guide you in the wrong direction. So that's the first thing I want to do as a lawyer, is listen to the client.
Yeah, that's awesome. Thank you for that. And in terms of resources, we could use your website to learn more. Of course, we got to do our own research as well. What other resources do you suggest that we use? Like maybe a book, or some online resource?
Yeah, I mean, I'm not really going to suggest a book. I'm going to suggest something else which might be unusual. And I bet I bet this is not something that every lawyer would say. So, but it's something that I would suggest, and that is you should keep up with the major case law in this area, and that's not hard to do. If you set your Google so that it is consistently telling you every day the cases that came down on the copyright or trademark with respect to video games, you'll get a whole bunch of cases. Most of them, not all, but most will be in the federal courts all over the United States. And I'm not asking you to read them so that you can write a legal brief or that you can sue somebody on your own. That's not where I'm coming from. But I am saying that a lot of these cases go into tremendous detail about the video game itself and the nuance of the development process. And you'll understand that. They're not written in such an obtuse way that there's nothing there of value for the person who is in the video gaming industry. There are things that will resonate with you. And so it's not a substitute for a lawyer. It's not a substitute for legal advice. And there'll probably be some legal concepts you're not familiar with, but you're reading them so that you can see the holding and understand the factual basis for why the judge held the way he did. What was it about that video game that was or was not infringing?
I would definitely link those cases up because it's definitely something we should be reading into. Overall, give us like a quick step-by-step action to take while creating a video game to ensure we're taking like all the precautions necessary to remain safe.
Yeah, I'm glad you asked that because I'm a writer, so I've written books, and I noticed that my writing improved dramatically when I learned to prepare a robust outline. And I'm going to tell you that as someone who is doing the video gaming development, what your listeners should be doing is creating a script. It should even look like a film or television script, and it should explain what the characters are doing, what the dialogue is, what the scene looks like, and what is happening in those scenes. And there can be obviously a flow chart with variations on things based upon what the person playing the game does, and with actual pictures and mock-ups and diagrams and things like that, but in the sense of an outline. Now, what you do with that outline is two things. Number one, actually creating that outline will help you to create the world of your video game. So it should help you artistically. There's a famous saying, and I know I'm going to butcher this saying, but there's a famous saying that, you should think like an artist and work like an accountant. And what that means is that you should have great ideas and imagination and fantasies and everything so you can have an artistic expression, but then you should put pen to paper. You should hit that keyboard. You should create that mock-up on your computer as if you are just coming to work every day and working 12 hours a day, and it's just being relentless to get the thing done. And then once you're done with that, you should show it to a lawyer and let the lawyer see what you intend to do. This is before you put the code in, before you go to all that trouble. Because if there's an obvious mistake or the obvious problem with some legal issue that you're overlooking, let us tell you now by way of the mock-up, because that's quicker than you doing all the code and making the whole thing functional, and then we have to tell you to delete things.
Yeah, you'd be saving us a ton of time if you find something that's copyrighted or trademarked. Wow, Gary, you have dropped so much value bombs, and I really got to thank you for giving us this opportunity to listen to you. We have reached the end. Go ahead and give us one last parting piece of guidance in how we can connect with you, and then we'll say goodbye.
Well, I like to work with the email. My email is gdn@gdnlaw.com. GDN is my initials, Gary David Nissenbaum. So please contact me at gdn@gdnlaw.com. If my if you want to look at my website, it's gdnlaw.com. And all I can say is that I have tremendous respect for what your audience is doing, the way that they are bringing such enjoyment to people and showing people how the digital world can actually be something that's fun and not just something that's threatening by way of security issues. And that's what we see in the news. I mean, this is actually a whole new level of artistic expression that your audience has created. So thank you very much. It's really been a privilege and honor to be on this podcast.
Yeah, thank you. And Game Does, ask a question. Gary just gave his email to you. So if you have any questions in regards to these legal matters, please ask him. Gary, it's been a pleasure. Thank you so much for sharing your knowledge with us. For that, we are truly grateful, and we will catch you next time.
Thank you. Take care.
Thank you, Game Does, for listening. And wow, that was a lot of information to take in, but so much things that we need to keep in mind. Don't forget that knowledge is only potential, power execution is the game. Go to GameDevLoadout.com and type in the number 79 in the search bar to find Gary episode for all the awesome show notes where you can connect with him and learn more about the copyrights and trademarks. Yeah, there's definitely a lot to it. Until then, keep on making games. I'm Tony Chan, and I'll catch you next Wednesday on the Game Dev Loadout podcast. Peace.